So when injury lawyers talk about negligence, they're talking about somebody acting with ordinary care or failing to act with ordinary care. A judge instructs the jury, it's called a charge. A judge charges the jury with this instruction to explain what the definition of negligence is. Negligence is the lack of ordinary care. It's as simple as that. This is called common law. Common law is different than statutory law. Statutory law is created by our legislative bodies, and they create statutes. Statutes, just a fancy name for law. Well, there's a lot of ways that people must act that is not controlled by a statute, one that's created by our legislature, and that's called common law. And under common law, negligence is the lack of ordinary care. So ordinary care is defined very simply as how one expects somebody else to act in the same or similar circumstances. And I'll read the charge. It goes on to say, it is a failure to use that degree of care that a reasonably prudent person would have used under the same circumstances. Negligence may arise from doing an act that a reasonably prudent person would not have done under the same circumstances, or, on the other hand, from failing to do an act that a reasonably prudent person would have done under the same circumstances. To cut through all of it, if somebody does something stupid and it results in somebody else being hurt, they're responsible for it. And when I use that term, something stupid, it's as simple as other people wouldn't have done the same thing. You would observe some action, say what they were doing just increased the risk of somebody else being hurt because of the action and activity that they were taking. Now, subtly, what I just said is the concept of what is foreseeability. People can do actions and activities, and if nobody could foresee that somebody would be hurt as a result of those actions, then that does not satisfy one of the elements of negligence law. Because not only does there have to be a breach of a duty, but that breach, it must be foreseeable that that breach will lead to somebody being harmed. And the judge specifically instructs the jury with respect to that. The judge, it's called the foreseeable charge, and it talks about foreseeability. And this, again, is common law. This is not defined by a statute or a regulation that was created by our legislature. And in common law, the judge would read, negligence requires both a reasonable, foreseeable danger of injury to another and conduct that is unreasonable in proportion to that danger. A person is not only responsible for the results of his or her conduct if the risk of injury is reasonably foreseeable. Importantly, the exact occurrence or exact injury does not have to be foreseeable, but injury as a result of negligent conduct must not merely be possible, but probable. So, when we say it must be foreseeable, the individual who undertakes the action and activity need not have foreseen that this specific instance and this specific time somebody would have been hurt, simply that it's possible that somebody would have been hurt. As an example, if a parent gives a teen driver the keys to a car, that driver doesn't have their full license and they still have a permit, a learner's permit, and the learner's permit requires that driver to only drive with licensed drivers, but the parent says, no, it's okay, you have your permit, go ahead. That action creates foreseeability for anything that the teen inexperienced driver may do. So now if the teen inexperienced driver is driving down the road and has a passenger in the car and leaves the roadway and strikes a tree, it's foreseeable that an individual who doesn't have the experience of a licensed driver may do that. It's not necessary to say to the parents, well, you didn't foresee specifically that your teen driver was going to drive off and hit this specific tree. The law doesn't require that. The law simply requires general foreseeability that somebody may be harmed by the activities that you do. And in that scenario, the parents would be equally responsible for giving the keys to their inexperienced teen driver. The concept of duty extends beyond just the individual person who necessarily caused the harm, but it goes beyond if you give the machinery or entrust. It's called negligent entrustment. You give something that can cause harm to somebody else to somebody who should not have been entrusted with it. The person who gives that instrumentality to the negligent actor is also responsible. So to take the legalese out of it, the parent who gives the keys to a permitted driver without requiring that driver to drive with a licensed operator is required, the parent is responsible for the actions of their inexperienced teen driver if they give them the keys. While we're talking about foreseeability, another concept related to foreseeability is one that a lot of people aren't aware of, and that is foreseeability to dangers to third persons. Now, what third persons are individuals who are not involved in the specific event itself, but they come upon the event afterwards. So, for example, a rescuer. If an individual causes a car crash and in the course of an emergency, a individual rushes to the scene to help the people at the crash site, the underlying original cause of that crash, that person would be responsible to the third person who came upon it. And the judge has a specific charge with respect to foreseeability, because it is foreseeable that if an emergency situation happens, we want to encourage people to come and try and assist. So the charge or the instructions are simply this. There is a principle of law that danger invites rescue. That means that someone who commits an act that a reasonably prudent person should know creates a risk of injury to somebody else or even themselves may be liable for injury sustained by another person who acted in an emergency to avoid or prevent that injury, provided that the actions of the injured person were reasonable in view of the emergency situation. A person acts reasonably in view of an emergency situation if he or she acted as a reasonably prudent person would in the same situation, even if later it appears the rescuer did not make the safest choice or exercise the best judgment. Because an emergency situation is a situation when there's no opportunity to think things through and it requires immediate reaction. The standard for those in an emergency situation is much lower because we want to encourage people to act, to try to help somebody who is in harm's way, and rather than limit what they would be recovered to by saying, oh, no, you shouldn't have undertaken that. If they were faced with an emergency situation, then their lesser choice of two is excused. A simple example is if a driver of a bus, as an example, is driving as a regular course of action, and a passenger on the bus screams, "There's a bomb on the bus." Now that bus driver is immediately faced with an emergency situation, if that bus driver slams on their brakes and causes injury to the people inside of the bus, then that bus driver's actions would be excused. However, if there's no emergency situation within the bus driver is driving and just slams on their brakes, and an individual in the bus, a passenger, sees somebody else falling forward and jumps out to help the person who was falling forward, and the rescuer is injured, that rescuer has the opportunity to recover for the bus driver. Not because they got injured when the bus stopped short, but when they took the action activity to leap out of their seat, and hypothetically, if they hurt their low back, they would be able to recover, even though it didn't come directly from that short stop, but they were now a rescuer in an emergency situation. Moving forward from foreseeability, we have the elements are duty, breach, proximate cause, and then damages. When we talk about proximate cause, the judge would read the following charge. And proximate cause, the word proximate often is confusing. Proximate is related to in time or in relationship to an event. And the easier way to think about it is this. If the event didn't happen, would the outcome have been the same? And if the outcome would not have been the same, then the event was the proximate cause of the outcome. Simple example. If somebody is in a car crash, a simple hit in the rear, and they start feeling, as a result of the crash, feel pains to their neck, and gradually over time that pain increases and increases, where 1 year after the crash, that individual requires surgery. The question is, was the crash the proximate cause of the necessity for the neck surgery? Well, the simple question would be, if the crash didn't happen, would that person have still required neck surgery? And if the physician says absolutely not, then the crash, even though it was 1 year before, was the proximate cause for the necessity of the neck surgery. So when the judge talks to a jury and instructs them as to what the definition of proximate cause is, the judge, he or she, would read the following. Proximate cause is an act or omission, and an act or omission is regarded as a cause of an injury if it was a substantial factor in bringing about the injury. That is, if it had such an effect in producing the injury that reasonable people would regard it as the cause of the injury. Now, importantly, and the next sentence is critical, there may be more than one cause of an injury, but to be a substantial factor, it cannot be slight or trivial. You may, however, decide that a cause is substantial even if you assign a relatively small percentage to it. So the concept of proximate cause covers not just time in relationship to an event, but it also covers multiple causes of an injury. It need not be that somebody has a pristine neck or shoulder or knee, which is often the case, where those are the areas of the body that are frequently require surgery sometime after an event. But the question always is, well, was the crash or the injury producing an event the proximate cause for the surgery? And oftentimes what is argued is, well, they already had some type of degenerative condition because of their age or life's experiences, and the reason for the surgery was their age or life experiences or degeneration. Well, that may be true. And you're allowed to have those alternative reasons, but you can have multiple substantial factors that necessitated the surgical procedure. And so long as the crash was a substantial factor. It's not the substantial factor, because the law recognizes that injuries often have multiple origins, and the compounding of all of them will necessitate surgery. But ultimately, the crash need only be a substantial factor to satisfy the law. In relationship to foreseeability, oftentimes an individual is involved in some injury-producing event. They're then treated by a medical provider, and the medical provider performs, in the course of their delivery of medical care, unfortunately, a malpractice. And the question is often raised, who's responsible for the medical malpractice? Well, in law, there's a concept of foreseeable harm, and one of the foreseeable harms that is considered is medical malpractice. So the underlying the term is tortfeasor, the individual or corporation who caused the original event and caused the original injury. It is automatically foreseeable that the injured person may be subject to a medical malpractice such that the original tortfeasor, the original wrongdoer, is responsible not just for the injury that they caused, but also all of the medical malpractice injuries that flow from that. Now, as a simple example, a woman is in a vehicle and a car comes across and crosses over and hits her vehicle head on, causing significant injuries, broken bones, and let's say a broken sternum right at the chest bone. And that broken sternum causes some injury to the heart. And now her heart requires a surgical procedure, and she never would have required that surgical procedure if the underlying crash didn't happen and cause the sternal injury. If during the surgery to her heart there's a medical malpractice, the underlying car crash, the person who crossed over and hit her head on, is responsible for all the damages from that medical procedure to her heart. Now, although the person who crossed over and is fully responsible to the individual who was injured from the car crash, that doesn't limit the individual from the car crash to only recover from the negligent party that crossed over and struck her head on. She has the right, if she so chooses, to also sue the doctor directly for medical malpractice. In law, there's no double recovery. There would be a challenge for a jury to determine how much damages were caused from the car crash versus how much were caused from the medical malpractice. And oftentimes what lawyers choose to do is bring one case with two different defendants, the party responsible. One would be the operator of the car, the second would be the medical doctor. But the injured person can choose to only sue the individual who caused the car crash, the underlying car crash, and recover fully for the injuries from the car crash and the subsequent medical malpractice. Now you may ask, why would somebody choose one over the other? And the simple answer is it all depends on how much insurance is available for each individual. So if the car has a tremendous, let's say hypothetically it was a UPS truck that crossed over and caused the crash. UPS is a multi-billion-dollar corporation with significant assets and tremendous amount of insurance coverage. It wouldn't be necessary for the injured individual, although she was a victim of a medical malpractice, to bring a separate lawsuit against the doctor because of the complexity and expense of that case against the doctor. She would be wise to solely bring a case against UPS. If UPS in turn wants to argue that they're only responsible for a portion of the damages and the doctor should be responsible for the rest, the UPS is then allowed to pursue those damages from the doctor directly, but it doesn't affect the injured person. They can collect 100% from UPS, and then it's up to UPS to go after the doctor, which is a complex, difficult case. And the law is always in the favor of the injured person to give them those options. In the scenario, however, where they aren't struck by UPS, a UPS truck or some major corporation with significant insurance, they may opt to then sue the car driver and the doctor because generally most claims they technically are not limited to insurance, but that is what is readily available, and doctors are required to carry far more insurance than the small basic limits on a car, the insurance limits. So it's always fact specific, and it's always things that should be considered when deciding to start a lawsuit. Who are the right parties? And those decisions should be made in direct consult with the lawyer. The lawyer makes recommendations. Certainly experienced good lawyers can project and foresee exactly how the litigation would proceed and make legal representations and recommendations as to what the right and best course of action should be. Turning to different types of insurance coverage, there are many different types of insurance coverages that are important to have a general knowledge about with respect to injury law. And most of it depends on ownership. And what I'm specifically referring to, insurance coverages, is the wrongdoer, the tortfeasor, the negligent party, the person who failed to act reasonably. What level of insurance is available to cover those acts or actions by an insurance company? Before I go into detail with respect to all of those different types of insurances, there's an important concept to understand. Insurance only covers up to the amount of insurance that was purchased by the tortfeasor, by the wrongdoer. After that insurance policy is exhausted, this is what is important to understand. The individual who caused those actions or the corporation are responsible for all damages over and above the insurance limits. So if a very, very wealthy individual has the minimum insurance, depending on the state, it could be $10,000 minimum, $50,000, $25,000, $100,000. Each state legislature defines what is the minimum amount of insurance every car must have to go on the road. So in a particular state, if it's only $25,000 and a very wealthy person owns a car and only has $25,000, you should know you're not limited to that $25,000 of insurance. The individual is responsible for all the damages that are caused, and they only can rely on the insurance company to pay the first $25,000. They personally are responsible for everything over and above that. Most injury lawyers will limit the recovery to what the amount of insurance is available, as long as the wrongdoer, the tortfeasor, has been financially prudent. And by financially prudent is making sure that they've purchased enough insurance to generally cover a chunk of their assets. There's no bright line formula, but by definition, a negligent act is somebody acting in a way not with pre-thought, but as an accident. They lost their concentration for a period of time. They were distracted. They did something, but the outcome was not and there was no intent to harm somebody. And in those scenarios, if somebody has been financially prudent and purchased enough insurance, most injury lawyers would recommend to their clients that it should cover whatever it is, even though the injury may and the damages that were suffered are greater than the amount of available insurance. And the reason being, it's very difficult to collect a judgment, which is what would be required, against an individual because you can't freeze assets until you have a judgment. So the individual, the wrongdoer, can readily move their assets into families' names and basically become judgment proof if it's clear that the action or the money sought will go materially above the amount of insurance. So oftentimes, while it's an injustice to injured people sometimes in that they don't get to fully recover, sometimes it's better to resolve a case for the full amount of insurance and not pursue it against individuals who don't have a significant amount of assets, because at the end of the day, after all that energy and time spent and frankly the personal aggravation an individual feels that's been harmed and trying to collect, it's oftentimes better to resolve it for the amount of the insurance, put it behind them, and move on with a recognition that it is unfortunate that they were injured from somebody who did not have enough insurance. Which is what brings me to why I want to talk about insurance, why it's so important to not, and I'm going to talk specifically about car insurance. When it comes to car insurance, if somebody is in a car crash, you have basically two options. First option is be wholly dependent on the individual who caused the crash as to what you will recover. So that if the unfortunate event happens and you are, or a family member or a loved one is seriously injured, and it happens to be a new driver who just got their first car and purchased the minimum amount of insurance in the state, that's what you'll be limited to. The other alternative and the other option is to become, in essence, self-insured. And the concept of self-insured with respect to car insurance is called underinsurance or supplemental underinsurance. The way underinsurance works is regardless of who causes the crash and how much insurance they have, you have purchased from your own insurance company an amount of insurance that you know that you can recover. So the simple hypothetical that I will give is if you purchase $100,000 of liability and underinsurance coverage, you know that no matter what happens, if there is a car crash, that you will be entitled to, if the injuries warrant it, at least $100,000. Because if the person who causes the crash has less insurance than you, $25,000, you are entitled to collect the $25,000 from the wrongdoer, the negligent party, and the $75,000 difference from your own insurance company. And in some states, you can collect the full $100,000 from your own insurance company. It's very state specific. But understanding that, then hopefully it's clear that you then become self-insured. You're not wholly dependent upon an individual who causes a crash as to what you would recover. And here's the interesting thing about underinsurance in coverage. First, it's very inexpensive. You cannot purchase underinsurance unless you have a primary insurance policy on your car. So if you purchase $100,000 of insurance, and I'll make up the numbers, and your insurance costs $250 for that insurance, to then add the underinsurance, which says that if somebody else causes a crash and they have less insurance than you can collect the difference from your insurance company. It's nominal, maybe $10, $15. to make sure that your underinsurance also matches your liability, and I would strongly encourage it. Now, what many people are not aware of is that underinsurance doesn't just cover you or your car. Underinsurance covers any car crash for any resident relative in your household. So let me illustrate a few examples. If, for example, you have underinsurance of $100,000 and you have a child who's engaged in some sport, let's say a 10-year-old is playing Little League baseball, and she is getting picked up by her next-door neighbor. And her next-door neighbor, your next-door neighbor, is driving the kids to Little League baseball, and there's a crash. And your next-door neighbor only has $25,000 on the car that they're driving. Well, you're not limited to collect because your daughter's a passenger in the car. You'll be able to collect from not just the operator of the car, the $25,000. You can then, because your daughter is a resident relative in your household, go to your own insurance company, even though your car was not involved in the crash and your car had nothing to do with any component of it. You can collect the additional $75,000 from your own insurance company. You've paid the premiums to the insurance company for that benefit because one never knows when a car crash may happen, and you are purchasing that underinsurance as what I call self-insurance, that regardless of where it is, who is driving, as long as it is involved with a crash and a vehicle, you can always go to your own insurance company as a last resort, just in case something terrible happens. So I always encourage people, if possible, get the highest amount of underinsurance available, because that way you can rest assured that anybody in your household that is a relative, it's called a resident relative provision, anybody in your household is entitled to make a claim on your insurance company for any damages caused from a car crash, regardless of whose car is involved. Now, the question that's always asked is, well, why should my insurance company have to pay, and won't my premiums go up? Well, the reason why your insurance company has to pay is because you paid them money for that benefit. You paid them a premium for it. And now all you're doing is getting the benefit that you paid the premium for. The second component is, well, won't your rates go up? If they go up, and insurance companies can only increase your rates one time after a crash, but they don't always do. But that's the purpose of insurance. Too many people are trying to do the favor of an insurance company, and all insurance companies seem to do is collect premiums and never have to pay out. Well, insurance is for when you need them to pay out. And I think it's a little small-minded to not make a claim against a company that you paid premiums for and that owes you the money when this exact scenario occurs. So I strongly encourage people to make sure they have adequate underinsurance. As an example, I always share my personal insurance. My personal insurance is $5 million of insurance. Now that means that if myself or anybody driving my car gets into a crash and is the negligent party, is the one who failed to act reasonably, violated the vehicle and traffic law and caused a crash, and God forbid somebody is terribly hurt, if they pursued a claim against me, there would be the first amount of that the insurance company would cover would be $5 million. Now, the reason why I do that isn't because I expect myself or anybody driving one of my vehicles to cause a crash and do that. The real reason why I do that is because I also have $5 million of underinsurance. So what I know is no matter what, anybody in my family, any resident relative in my household, regardless of what car they're in, where a crash may happen, has the availability of $5 million of insurance if, God forbid, that they're seriously hurt in a car crash. And there are some terrible, terrible injuries that can happen in car crashes. And you don't want to be in a situation, if you can avoid it, where there's monies that are available to recover and not have them available to you. So I always encourage people, if get the most amount of underinsurance that is available to you, because that way you're protecting all of your loved ones in your household and yourself. You don't want to leave it to chance. Nobody wakes up in the morning and says, I'm going to get into a car crash today and be really hurt. Or somebody in my family is going to get into a car crash today and be really hurt. Nobody wants that. Nobody expects it. But it happens. And when it happens, you want to be prepared. And the best way to be prepared is by purchasing as much underinsurance as you possibly can. I'll share one story with you. I represented a physician. A doctor he was actually a hand surgeon, was driving down the road, and a teenage kid ran a stop sign, and he had his hands on the wheel. It came from his left, had his hands on the wheel. It caused his hand to hit the window, and he broke 3 of his fingers. As a result of breaking those fingers, he wasn't able to perform surgery anymore, and it was quite a significant injury to him. Well, the kid who caused the crash had only, at the time, $10,000 of insurance, and he owned. There was no other assets to pursue. So then I looked to the physician, and I said to the doctor, "Let me see your insurance." Well, there's 2 lines of insurance. He had liability. Liability is if you cause a crash, what the insurance company will cover you for. He had $1 million of liability insurance. So he was protected. Just in case somebody was going to pursue a claim against him, he was in good shape. But then the next line under it says underinsured coverage. And I asked him, do you know what underinsured coverage is? And he said, no. I said, did anybody explain it to you? Nobody ever explained it to him. What was his underinsured coverage? $10,000. That's all he self-insured. He could have self-insured up to $1 million, but because his insurance broker didn't properly explain it to him, the most he could recover was the $10,000 from this teenage kid, and that's all that we collected for him. But then when I said to him, if you were told and understood that to have the underinsurance go from $10,000 to $1 million would have cost only $50, $60, would you have done it? He said, of course I would have done it, but it was never explained to me. So I sued his insurance broker and collected him the $1 million anyway, but that's a rare and unique scenario, and you have to be careful. I don't want you to be in that situation. You need to self-protect ahead of time. So that's the core of underinsurance, and this is what it looks like when it gets illustrated out.